Hello and welcome to episode 63 of Let's Talk Immigration. I am immigration attorney Curtis Morrison, based in San Diego County, California, the United States. If you have a question for me today, if you could post that in the comments, either on Facebook or YouTube, they show up automatically. I think they're showing up from Twitter automatically too. That would be great. First, before I get to questions, I want to talk about the declarations of Carson Woo. Okay, I said declarations because we found another. So there are two declarations of Carson Woo. 1 second, let me fix that. There we go. So I'll share my screen to tell you what we're talking about. First of all, Carson Woo is employed by the Department of State. He is the acting director of the Office of Screening, Analysis, and Coordination Office. SAC is what they call that in the State Department. Basically, I came across a declaration from him last week, a few days ago, and since then I've came across another declaration that the government pointed me to by accident that he gave in September. And I want to go over what he revealed to us about how the AP process works back in September, and I didn't even notice it, and then go to the declaration from January and disclose what he revealed to us is in January. Carson Woo he's like Santa Claus with secrets. He just like gives you all the information that you want to know about DS 5535 administrative processing vetting. Very niche kind of Santa Claus. Anyway, here we go. First, before we get to the highlighted section, I think this is funny. He's aware that there's been a drastic increase in visa-related litigation cases from 250 in 2018 to over 2,000 in 2022. You are welcome. Okay. He says that nearly half are related to the consular officer's refusal of a visa application under 221G. See, that's not actually a refusal, though. That's a non-final decision. 221G, 220,000 people get that a year. It's where they go to the interview and the consular officer says, we're not ready to issue you a visa yet, and gives you your passport back, and your CX says refused. But really, you're just waiting either for them to review a document that you have to get back to them, or for them to review your responses to the DS 5535 supplemental questions for visa applicants. Okay, so let's go to the next paragraph here. The department does not expedite vetting solely based on someone filing a civil action seeking mandamus relief. No, they don't, but this sentence is fun. When notified of litigation, the screening office assesses the visa case to determine whether the case is being processed consistent with existing standards. For example, the screening office will confirm that the screening is correct for the identified security concern, or that the review has been appropriately processed consistent with the department's priorities. This is great. Let me tell you why. I knew that this was happening, but it's really good to see Mr. Woo disclose it. Okay. Sometimes we file a mandamus lawsuit and we find immediately they request DS 5535 responses. Why do they do that? Because they lost the first ones, or they never submit. The consular officer received, but they never submitted a security advisory opinion to the SAC. So let's just say that mandamus lawsuits don't work, which is not true. They do definitely work at this. When you file a mandamus lawsuit, the State Department makes sure that they're following the procedure and the case is not lost. Since I've seen that happen so many times, I would say mandamus lawsuits are worth it just for that. But also, they do accelerate the adjudication of unreasonably delayed applications, no matter what Mr. Woo says here, because We've seen it. Okay. Paragraph 4. He says on September the 22nd, 2023, the department has over 59,000 open requests for security advisory opinions. That's interesting. I would say remember it, but I'm going to go ahead and tell you. When we get to his new declaration from January 5th, it's up to 66,000. So what that tells us is the number of people in AP in October, November, December, 3 months went up 11%. Okay. If it keeps going like that, it'll double within the year. So let's hope that that is temporary and not a sign of a new Blinken Biden policy. Okay. I noticed that the first number for 59,000 was from September 22nd, 2023. What's happened since then? Internationally, the conflict between Hamas and Israel and the subsequent conflicts with Lebanon and Syria and Yemen and Iran and that in Iraq, the whole region, that very well could be the rationale for why they're putting more people in AP or keeping them in. I don't know. I'm just speculating. It is an odd coincidence that the number of people in AP have surged since that conflict. Okay. Okay, paragraph 5 of Carson Woo's September declaration just says, hey, we're not going to tell you how this stuff really works, because if we did, then visa applicants would use that information to try to evade detection by a consular officer on whether the applicant is eligible for a visa. To be clear, I don't want anyone to do that. I want visa applicants to be honest with consular officers always. It's the best policy. I do disagree with this paragraph, though, because I think that transparency in a process is sort of fundamentally important to democracy and like fair government and justice. And so I don't like these secrets that they like to do. So, okay, that was Carson Woo's declaration from September. Now we're switching gears. We're going to get in our time machine and go to Carson Woo's declaration from January 5th. We're here. 3 months later, he talks about different things in this declaration because it was responsive to different issues. These came from lawsuits that actually were not my lawsuits. There were 2 other attorneys' lawsuits. Other than myself, great attorneys. I'm not the only attorney that files mandamus lawsuits. Some of you did not know that. There are others out there. Not a bunch. Okay, first of all, security advisory opinions. The initials for that is SAO. When the consular officer collects the DS-5535 from the applicant after the interview, whether it's an immigrant visa or non-immigrant visa interview, those responses are formatted by the consular officer into a security advisory opinion request, and it is sent to SAC, which, remember, is the Office of Screening, Analysis, and Coordination. That's the office that Mr. Woo runs, okay? This declaration goes all the way back to 2001 and describes how we got here, okay? I don't want to go into that. Everybody knows what happened in September 1. So it talks about how the consular officer identifies security visa ineligibility. Okay. First of all, this starts, national security screening starts when the whether a DS-160 or DS-260 is submitted. That's something that a lot of people might not know, that they start vetting the national security interest right after you complete the DS-160 or 260, even though you may not attend interview for the next 1 to 5 years or something. Okay. No, nothing new there. Okay, so before the visa may be issued, the consular officers are required by statute to perform a check of the automated lookout systems. This is where we run into problems, because these automated lookout systems have lots of information that's probably false and misleading, and causes cases to get false positives flags, right? So the first system is class. I want to see if I can make this bigger for those of you trying to read on your screens right now. There we go. Okay, class contains 36 million records of persons. That's a lot of records, right? And it's populated through the terrorist screening database. Okay. The second database that they screen through is the consular consulated database. Basically, the way your name gets in there is if you ever apply for a visa before, except they only got them back to 1998. Surprised they revealed that there. So if you applied for a visa in 2000 or 1999 or 2010 for like a visitor visa or a student visa and it was refused or whatever, they still have that information and it is stored in the CCD, okay? And so when you go to a visa application now, they're going to look this up. Also, all visa applicants are subjected to an interagency terrorism review, okay? With biographical and biometric reviews. I forgot on this last one, on class, they're basically searching names and variation in names, okay? So if your name, suggestion, name your child something that sounds, that doesn't have nobody else has that name. And that way they won't be subject to these problems. Okay. Number 14. This is the one where I could be wrong and we'll never know in my lifetime, but I think this is the one that's causing the problems. The Kingfisher expansion. I've read about this in one place on the internet before, so I was really excited to see it pop up in this declaration. This is a vetting system that they don't reveal a lot of information about. And if derogatory information exists about an applicant, the consular officer receives a red light response to one of the automated lookout systems. These applicants have come back to me before and said that there was a point in their interview at the end where the consular officer's face, all the happiness went out and they got sad and they looked at and you could tell something happened on the screen. And I think it's this Kingfisher stuff, okay? Because a red light response comes out into one of the automated lookout systems. I also think that this involves some sort of artificial intelligence that the State Department does not want the public to know that they're using because they already were told not to use. Okay, I might be wrong. This is just me speculating about theories, okay? So when a consular officer encounters a red light, it's funny they call them red light. I wonder if they actually come up red on the screen. The consular officer is required to take prescribed steps necessary to assess properly whether the applicant has incurred a ground of visa ineligibility. If it relates to 212A3, which is kind of involves national security and terrorism, they have to refuse under 221G, the non-final decision, and request an SAO from SAC, which is a security advisory opinion from Carson's department over here at Screening Analysis and Coordination. Okay, this is fun. it talks about the National Vetting Center and how they're involved. And it talks about the president as if, but this happened in February 6th, 2018. Who was president February 6th, 2018? That's President Trump. I'm not saying that Carson Woo is implementing Trump's anti-immigrant policies. He's saying it under oath, under penalty of perjury. Okay? I'm not saying it. He's saying it right there. There are the words. The president in 2018 established the National Vetting Center. The National Vetting Center is intended to enhance collaboration between multiple U.S. agencies so that they share data for national security vetting. It's not necessarily a bad thing. Okay, number 17. We're getting there. 2 more pages. The department anticipates that moving national security vetting to the National Vetting Center will create efficiency in the vetting process that will ultimately benefit all visa applicants and also enhance border security by providing more robust screening of applicants. Well, it was created in 2018 and it's 6 years later and it's still not done it. So I don't know if we have to give, who is it, General Dynamics or some contractor, we have to give them a couple more $1 billion before this happens, but it hasn't happened yet. I have not seen more efficient process. It's interesting though, because they rolled out in the last year of the Trump administration something that was supposed to speed things up and do the vetting before the interview. And then that just disappeared. We haven't heard anything about it. So I don't know if this is related to that. I don't know. Okay, paragraph 18. Let me see here. So if a consular officer uncovers facts during the interview, like in response to questions they ask, that could also trigger an SAO request. Remember that security advisory opinion. So your interview is important. Do not go into your interview just casually chit-chatting about everything without thinking before you talk. Still want you to be honest, but just be precise in your language. Okay. We all knew this. The consular officers may not issue a visa unless they are satisfied the applicant is eligible for the visa. But we did not know this. In any case where an SAO is required, a consular officer must wait for a response, which will provide a recommendation on whether the sufficient information exists to support a security-related ineligibility finding. Actually, we sort of knew that. I thought that this was going to be something else that's coming. Okay, so it talks about SAO resources, which is something we've dreamed about for years. And here it is. Here's the information on paper right now in live. Okay, let's talk immigration. SAO, Carson's little department of the State Department, apparently has 2 divisions: the Counterterrorism Division and the Screening Division. Okay, the Counterterrorism Division at present has about 47,000 SAO requests pending, and the Screening Division has 19,000. Well, I added those up. That's 66,000. When they said it was 59,000, Carson said it was 59,000 in September. So it's gone up 11%. You know, you're not going to see that anywhere on the news or anything, but Carson's telling it to us in these 2 declarations, and I'm putting them side by side, and I think I'm the first person to do that. I don't know. This is interesting. It says how many they do annually. So 115,000 annually from the Counterterrorism Division and 75,000 annually from the Screening Division. So if you add those together, you get 190,000. I remember in 2022, there were 220,000 people that went into 221G, were refused under 221G. So that means most people being refused under 221G now are getting DS-55, are going in AP related to a security advisory opinion, which probably is triggered, probably is done in concert with the DS 5535 responses. Okay. Okay, last page. Sometimes they disagree. The people that work at the SAC will disagree on whether or not someone's ineligible for a visa, and so they've got procedures for where they go back and forth and argue. And until they agree, the consular officer cannot reopen that visa application. That's interesting, because sometimes we see DS-260s that say incomplete, that have been opened after the interview, and you're like, oh, should I submit that? Should I change it? Is the consular officer waiting for me to do something on a change? And we encourage people to go in and make things right and resubmit. But apparently, the consular officer can't even see the visa application, which at least we could see it. Visa applicants could see it. Consular officer could not see a visa application while it's in AP, according to this last sentence of 26. Okay. And this is the most explosive, nuclear explosive sentence that has come in a government declaration since I've been an attorney. Because of the complexity of this process, SAO, Security Advisory Opinions, requests can be neither addressed nor resolved in a first in, first out basis. So, all these times where the government's filing motions to dismiss, hundreds of cases where the government has filed motions to dismiss and saying, hey, these plaintiffs are trying to skip the place in line and there's a queue and they need to follow the queue. Those were lies. There's no line. There's no queue. It's more of a pool, really. And Carson just puts it there. So I've spent the last 4 days, I think, filing notices of supplemental authority, letting judges know that the Department of Justice and the State Department have not been forthright about this information. I've let dozens of judges know at this point. If you have a pending motion to dismiss that's fully briefed and you are represented by another immigration attorney, send them to me to get this declaration so that they can file notices of supplemental authority in your case and let the judge know. Now, the government's not going to like this. I've already got a response in one of these filings where I filed this, and the funny thing is the government's response was, we never said anything about a queue. That wasn't us. We were talking about those other cases, and those other cases were about queues, but we weren't talking about queues. I mean, it was really, it's like that Star Wars scene where Obi-Wan Kenobi says, these are not the droids you're looking for. You know, that's kind of what it feels like. Like, we're all here. We all saw you argue that there's a queue. I produced a declaration from one of your leadership that says no queue. And now all of a sudden you're pretending like this never happened. I'm like, no, this happened. Okay. So that's the declarations of Carson Woo. I hope you enjoyed the show. Now I will take questions, and that will be fun. And if anybody wants to join me in today's live, let me know, and I'll put you in if I could figure out how. First question. Hello. When a response is made to a motion to dismiss, okay, a response to motion to dismiss is filed by the plaintiffs, a response in opposition. The government files their subsequent response. Okay, lawyers, we call that a reply. The government files their reply. Usually 7 days after the response. How do we know? How long do we have to wait for the judge to decide? Oh, this is a difficult question. First of all, that's not always what you're waiting on. There are two outcomes that can happen at that point. One is the State Department can decide to do the final clearance, probably issue the visa, because they don't want to see what the judge is going to do either. Okay, they would rather this be done than a judge asking them questions. Okay, that's the one thing that we hope for, and that's very likely. It could happen, and that could happen quickly, or it could take a long time. I've had it happen in days, and I've had it happen in weeks, and I've had it happen in months. Okay. When it happens in months, it's probably not because of the lawsuit. It's because it's organically, finally, they've accidentally found the file and they've decided to finish it. We don't know. They'll never disclose that. Usually they won't disclose that. Okay. The second way it could happen only happens in less than like 3% of cases. And that's what you're talking about. When a judge actually issues an order on a motion to dismiss, extremely rare that that happens. But when it does happen, it does not happen within days of the reply. It usually happens within weeks or months. Sometimes 1 month, sometimes 2, sometimes 10. Okay. Sometimes judges realize that it's better for the visa applicants if they don't issue an order, if their order is going to be, I don't know. I can't go inside the minds of judges. I can't do that. I can try, but I can't. So I don't know the answer to your question. Some judges, Judge Kohler Kelly in DC is very quick with her orders on motions to dismiss. Okay. But other judges take more time. If you go to my blog, readygolaw.com, and my other blog, I've got 2 blogs. I've got 2 law firms. I confuse myself. I don't even know where I am. I have wrote a blog entry where I have listed the last 8 or 9 times that the government has filed a motion to dismiss and it has been denied, or the judge says, no, we're not dismissing the lawsuit. We're going to continue. About half of those were AP cases. Half of them were NBC mandamuses. Okay. DV 2021, what about? Well, first of all, you're just saying DV 2021, and you're not telling me if you were a plaintiff in Good Luck or Ray or Go. And so I have to start at the beginning to answer your question because you're being vague. So let's do that. The majority of DV 2021 journeys ended on October 1st, 2021. The journeys that remain are the Good Luck plaintiffs, the Go plaintiffs, and the 2021 selectees who were waiting on interviews from embassies that were designated in our Ray versus Biden case. Okay. So if you are in one of those situations, then you're waiting on the outcome of the appeal. But if you were not in one of those situations, your journey ended October 1st, 2021. Okay. Is there news about DV 2020? See, the question, I would prefer to know if you were a plaintiff, but in 2021, if you were not issued a visa before April, then you are automatically a Gomez class member, and we are still awaiting the outcome of the appeal on the Gomez matter, which is now related and tied with the Good Luck appeal. Both of those appeals are before the Circuit Court of Appeals for the District Court of Columbia. We're still waiting the outcome. Okay, AAI says, I had a visa add a child in 1991. I told them about it, but I wasn't aware of all the details. I was unfair. I was unfair, an infant. I had an infant. I need context. Why are you asking me this question? Do you have a pending visa application? Also, it sounds like a very specific situation. You need to talk to an attorney. So try to reach me on Telegram or WhatsApp or somebody. Talk to an attorney. MT says, is it possible to file a writ of mandamus while remaining anonymous? Great question, MT. Yes, but you need the judge's permission. It's called a motion for pseudonym. And basically, we can ask the judge's permission for you to be called like John Doe or Jane Doe. But we need good grounds for that, okay? We need good cause. In the past, good cause has meant like someone in danger, I've done a lot of pseudonym motions for people in Ron, their petitioners, for example, because their beneficiaries may be in danger. Here, I'm looking for the law on this, but I have to be able to spell pseudonym right, and it's one of the hardest words in the English language to spell. P-S-E-U. Well, I can't. So I can't find the other fact. I have the factors someplace real quick to get to on my desktop, but I can't find it. If your reason for wanting to file anonymous is what is going to be important to the court, if your reason is I'm a private person, it's not going to work. Courts are a transparent place, okay? But if your reason is someone's going to be in harm or there's going to be a problem, then there is a chance that a judge will grant the pseudonym motion. Every one I've ever written was granted, except one in the Eastern District of California. One time they said it's sealed only for a certain amount of time, and then it's not sealed, like for 2 years. It's kind of weird. Okay. I do want to point out something, though. If you file a mandamus lawsuit, it is under Federal Rule of Civil Procedure 5.2, 5-2. It's one of the exceptions for the lawsuits where the filings can be downloaded remotely from anybody. So in other words, when you file a mandamus lawsuit, when we file it, we enter 465 on the civil cover sheet. And what happens is only your attorney, the government attorney that enters his appearance, and the judge can access that the filings. The exception is orders. When a judge makes an order, anybody can see that, unless it's sealed. But so, which is rare. Anyway, what I'm getting at is immigration cases. You can do anonymous, but it takes an extra step. It's a lot of work. We charge extra. We charge $1,000 extra if you want to go with pseudonyms. But also, I want to know the reason first to make sure that it's viable. Okay. DV 2021. That's great, but you need to be more specific. I have a lot of publications on key opinion leader in my field. That is not going to go. You're not going to get a pseudonym motion for that. We can try it, but it's not going to work because that's not relevant. Just because you have a lot of publications and key opinion leaders in your field, why is that relevant? I mean, unless your field is ending democracy or something, because in democracy, like, you should be able to sue your government when your government does something wrong. There's nothing wrong with doing this, okay? I, on a regular basis, represent people who work for the United States government, suing the United States government, who is because their loved ones, their spouses, their parents, fiancés, visa applications are being delayed. So if U.S. government employees could sue their employer, they could sue the U.S. government. You should relax and sue the government too. Okay. Karok says, hi, DV 2021. Is there any way to ask the Court of Appeals to tell us the result? Karok, if you're just DV 2021 and you're not a plaintiff in good luck and you're not a Ray waiting for a Ray embassy, your visa journey is already over. It was over October 1st, 2021. Okay. I need people to be using specific language so I don't have to keep repeating myself and explaining the history of DV to the world. Okay. I suspect, let me see if you're commenting since then. I suspect you're a good luck plaintiff. If you're a good luck plaintiff, the answer is no, we cannot ask the Court of Appeals to tell us the result. Okay. We do not want the quickest result. We want the just result. And the circuit court, the court themselves, the judges, they are in the best position to manage their caseload. It is presumptuous and arrogant to think that we can go in there and tell them that our case is more important than their other cases, and we don't even know what their other cases are. I know for that specific court, some of the other cases involve the future of democracy because they involve Donald Trump and that mess. So if you're going to ask about 2021, y'all, you need to start saying good luck, or you need to say Ray, or you need to say go, or you need to say not a plaintiff. I just need specificity. I need you to be specific with your questions. Okay. So I have all the questions over there. I've already answered them. Any more questions? Or are we going to wrap up early today? I thought there would be more questions about the declarations from Carson Woo. I was excited about the declarations from Carson Woo. So, does anybody want to join me? You're making me sad. When will they move to National Vetting Center? We don't know that. What it said here, good question. The department is actively involved in working with the National Vetting Center to shift the security vetting of visa applicants from KFE vetting system discussed above to the National Vetting Center. The department transferred the national security vetting of non-immigrant visa applicants to the National Vetting Center in October 2022. Oh, here it says, with immigrant visa vetting to follow sometime in 2024. Sometime in 2024 is the answer to your question. But I don't believe them. It would be great if that happened. Maybe. I don't see a difference. I see non-immigrants in AP as long as I always have. It seems like the Iranian students are in AP longer than they've ever been. Like I'm running across many that have been in AP for 6 months or a year, and that's what we saw during the Trump administration. So I don't see what changed. It seems like non-immigrants are moving faster than immigrant visa AP. Maybe. Well, they're being done at a different place, apparently. Interesting. Okay. So Laura says, I'm a good person. Thanks for your answer all the time. Well, you're a good person too. Thank you for joining the live. MC says, check red bus H1B F1 move faster than CR1AB. Interesting. Thank you for sharing that. Okay, I'm gonna wrap up early. Anybody has any questions, you can hit me up on Telegram or WhatsApp. And I will see you next week for episode 64 of Let's Talk Immigration. Until then, be safe.